Hey guys, in this video we are going to talk about 7 ways that your US citizen child can help you get a lawful status or stay in the United States. Visit us at Swat&Vee channel with questions to see how best we can help you out choose your process. Please don't forget to subscribe if you're new to the channel. Let's get started. Here are 7 things that I want you to think about if you're a parent of a US citizen child. The first way the child can help you is if that child is 20 years old, at least 21 years old, and a US citizen. The child could obviously file for you for a green card. If you are here in the United States, you would go through a process known as adjustment of status so that you could get your green card right here in the United States. However, if you had entered without inspection, or you cannot prove lawful admission or inspection, or you are outside of the United States, you will go through a consular process abroad at a US embassy where you're going to be interviewed for the immigrant visa, and then you will come into the United States. So that's one obvious way that the child could help you. Now, the second way is that they could help you is if you are in removal proceedings, deportation proceedings. You can apply for a cancellation of removal if you're eligible for it. Cancellation of removal is very complex. I would highly recommend that you have professional help with this if you are in removal. It's not available to everyone in removal. Only certain people are eligible for this. But if you are eligible for cancellation of removal, a child who is under 21 and unmarried US citizen or green card holder child can help you if you could show the judge some very strong sympathetic facts related to that child and why you need to be here in the United States for the sake of this child. The third way that a child can help you is if you are in removal, which could be considered for a waiver for fraud or misrepresentation. If you have been charged with fraud or misrepresentation related to your immigrant visa, your admission into the United States, or even your green card, you cannot apply, but you could ask for this waiver in court, and the judge can consider it if you have a US citizen child of any age. This waiver is different from another form of waiver that you guys may have heard me talk about before, which is the Form 601 waiver or waive inadmissibility problems like fraud or misrepresentation. But that waiver goes to USCIS and you cannot use a child for that. You could only use a spouse or parent who is a US citizen or a green card holder. So just understand that there is a big difference between those two types of waivers. Fourthly, a child can help you go through an immigration humanitarian process known as humanitarian parole, and this is for those who are outside of America and as well as those inside America who have strong humanitarian reasons why they should have a temporary lawful status here in the United States. Perhaps because of this child and some of the things that this child is going through, medically speaking or otherwise, you could use the child as a factor in your argument why you should be allowed to get this humanitarian parole. The fifth way is also kind of similar to that, but the procedures are different. But it's known as medical deferred action. And for this one, you know you've got to have some serious medical conditions going on with the child, like maybe Down syndrome, autism, or other serious conditions. And you're asking that ICE does not take any action to remove you from the United States during this 2-year period that you've been granted the status. Now, this status does not lead to a green card and it's very temporary, although you can apply for another one at the end of the 2-year period. But just know that it also comes with a EAD, which is a major benefit because you can get a work permit. The sixth way that a child could help you is if you had gone through the removal process and the judge issued a removal order against you. Maybe you had appealed the decision and it was denied, and now you are desperate. You've basically exhausted pretty much all of your remedies, so to speak. You could apply for a state of removal to either the Board of Immigration Appeals, federal courts, or even to ICE. And through a child, you could argue that you have a young child here or a US citizen child, and that could be considered as one of the factors to grant you stay or removal. Which, by the way, if you're granted stay of removal, you would be eligible for a work permit as well. The last way that I can think of is a child can help a parent who has been temporarily detained by ICE. For example, if ICE shows up at your house, arrest you, take you, detain you that day, bring you down to the office, and you know for a fact that you are the only guardian for the child or children, ICE may release the parent that same day. This helps the parent get out of detention faster and get to stay here longer. These are the 7 ways that a US citizen child can help their parents as the parents is here in an unlawful status. I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people will want to check this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe or hit on the notification bell for more immigration updates. Bye!